Delighted to be here with you this afternoon to spend 60 minutes reflecting on diversity and inclusion in the legal sector and why the sector is not leading in this space compared with others. That in the context, of course, of the sector being the guardian of people's legal rights and the rule of law. This does not seem particularly satisfactory. At the Bridge Group, we work across sectors exploring diversity and inclusion with a particular focus on data, on quant data and the evidence base around this. But of course, much of our work also includes what Sophie and Michelle have exemplified here around qualitative and lived experience comments also really mattering. So just in terms of structure, if I may, I'd just like to spend 5 or 10 minutes sort of scene setting and sharing with you some of the evidence base that we have gathered and drawing on evidence from elsewhere as well. And then it will be my pleasure to invite Ingrid, Natasha, Michelle and Tiernan to reflect on what they've been hearing. And then I promise we will leave plenty of space for audience challenge, questions, your additional insights as well. I'm sure we've as much to learn from the room as you have from us. You will have observed a really significant and intensifying focus on diversity and inclusion across professional services, but perhaps most acutely, I would argue, and I'll give you some evidence to substantiate this in a second, most acutely in the legal sector. There has been a focus, as you referenced, on protected characteristics. In our work, we've particularly focused on gender, ethnicity, race and disability. And also increasingly, and I was delighted to hear you reference this, around socioeconomic background as well. And we have only really, I think, in the last few years begun to really understand how that background characteristic affects access to and progression in the legal sector. And I have some data points hot off the press to share with you this afternoon. Last year, we at the Bridge Group had the pleasure of being commissioned by the Legal Services Board to do a comprehensive review of the literature and practice in the legal sector in this area, including best recommendations for the role of regulators in this space. And we drew on evidence from other sectors as well as within the legal sector in England, in Wales and across the country as well. This work, and I encourage you to look at it, of course I would, it's available free of charge, has contributed to this increasingly robust evidence base around diversity and inclusion. It is remarkable to me to hear the number of people who take this agenda seriously, but for whom the lack of evidence base seems just fine. We need much more evidence in this space about where we should target efforts, what's really happening in the system and what works best in terms of interventions. And we know from our work this is very much about collective responsibility and collaborative action across legal firms, across regulators, across educators. And there is no, as Ingrid and I were discussing earlier, there is no silver bullet here, I'm afraid. If you were hoping for 3 top tips, you might get them, but it's not an easy task, this one, and I hope we won't oversimplify it this afternoon. So our work extends from early outreach work, busting some of those myths that young people have about the legal profession. For us, our evidence says that's often less about young people's aspirations and about their differential access to opportunities. I was talking with one young woman after an outreach event a law firm ran last week, and she said, my problem is not lack of aspiration. The idea that parents don't have aspirations for their children, I think, is a distracting myth. It's about access to opportunities and how they present to people in different ways. Right through to admissions for law schools. We published a piece last year that demonstrated that amongst the most competitive law schools, those candidates from lower socioeconomic backgrounds were admitted on average with higher grades compared with those from higher socioeconomic backgrounds. We at the Bridge Group would call that perpetuating inequality. Watch out for it, I encourage you. We know in the legal sector that data is a real strength. I can say unequivocally, we have more data in the legal sector around diversity and inclusion than any other sector has in its arsenal. That is to say, though, that the collection of data is not an intervention in itself. I get concerned when we think that is the main intervention around D&I. Of course, it's necessary, but not sufficient. We owe this agenda the fact that we can understand it properly with the data, but that shouldn't hinder action. So we know, for example, based on the latest SRA data, if you haven't accessed it already, the SRA, I should add, is an exemplar for other sectors around the collection of data and the way it's presented. We know that 52% of practicing lawyers are women. There's still a huge gap, you'll know, around seniority between men and women. That has closed moderately over the last 2 years. That 17% of practicing lawyers are from a BAME background. Again, we warn you against homogenising that group as though everyone who were non-white was the same. The progress amongst people of black heritage is very, very slow. The percentage point increase is under 1%. So that BAME population is increasing, but not amongst black heritage employees in any way that we would see as progressive. And we know that 5% of practicing lawyers are disabled, but many choose not to disclose, and people disclose in different ways. There are similar data sets available in the judiciary, of course, and Ingrid, I know you'll come to the D&I strategy, the judicial D&I strategy in our panel shortly. This data, importantly, of course, looks very different by size of firm, by geography. It'll be great to welcome Michelle to the panel later, who works at a regional law firm in the West Midlands. But we do know across this data that it is socioeconomic background that has a stronger effect on access to the legal profession and progression within it compared to any other diversity characteristic. Let me footnote that strongly in bold by saying I'm not suggesting we should play diversity top trumps. What I am saying that the data is telling us if we don't pay attention to that particular background characteristic, we miss a really important part of the jigsaw. So we know that just under a quarter, 23% of practicing lawyers went to a fee-paying school. That compares with about the same percentage of MPs and about the same percentage of FTSE 350 chief executives. That compares to 7.5% of the national population. We may not think that's a problem, of course, that those from independent schools are overrepresented threefold in the legal profession. We have similar data, and this is testament again to the data collection and sharing among legal services firms. We know, for example, that amongst the 10 largest city law firms, listen to this stat carefully because I think it's the most important one I might share this afternoon, graduate trainees from lower socioeconomic backgrounds are 40% more likely to be in the top 10% of performers. Graduate trainees from lower socioeconomic backgrounds are 40% more likely to be in that top decile of performers. Clifford Chance were involved in this research. But they're much more likely to leave the profession and much less likely to progress. If a sector needs a business case for D&I, and perhaps it shouldn't, there's the business case for law. It's stronger in law than it is in any other sector, I would argue. When we've looked at progression to partner, who makes partner, we've looked at the way in which background characteristics affect the time it takes. It's socioeconomic background and ethnicity that have the strongest effect. Amongst those same 10 firms, those from lower socioeconomic backgrounds take on average 1 year and 3/4 longer to reach partner. If you're a black woman from a lower socioeconomic background, it's more like 4 years longer. This is what the data is telling us. I would suggest to you it's pretty incontestable. But we know this. None of what I've said to you probably is particularly surprising. We need the data to really evidence these things and to understand them. But just as I finish and invite our panel up, what does the evidence suggest about what works? Here we have some methodological challenges around demonstrating cause and effect. We know the following, though, is true. We know in our evidence, working with a whole range of firms across professional services, and particularly in the law, that things like diversity training make very little difference. and particularly what has become labelled as unconscious bias training. These biases aren't unconscious. And it's also typically unhelpful, we observe in the literature, to individualise and psychologise these problems as though they were individual and not systemic. We need to embrace these challenges as systemic as much as we do around individual preferences and choices as well. Here are 5 quick things we know do work. And they're all really rooted in talent. These are not about D&I initiatives, they're about good talent management. We talk a lot at the Bridge Group to the majority group. By that I mean mainly white affluent men, but not only. We know that rooting this in talent is the really important thing here, and that diversity isn't out to get anyone. It's only out to get the people who are not the best person for the job that they're in, and the people who might have got into their jobs through anything else other than talent and hard work. Gosh, lots of assumptions loaded into that paragraph. Maybe we can come back to it in the panel. We know in outreach work experience has a stronger effect compared with anything else, compared even with really robust mentoring programs. Making work experience more geographically accessible, targeting it really effectively to those who will benefit most, and making sure that work experience candidates have a chance to reflect on their experiences afterwards. 1. 2, contextual recruitment. We know that, for example, A-level grades are a strong signal of potential for a role. They are an even stronger signal if they are considered in the context in which they were achieved. To put it more bluntly and slightly provocatively, if you get 2 A's and a B in your A-levels in the comprehensive school in Doncaster, around the corner from where I live, you have been exceptional. That's a pretty strong signal of talent. Why pick on this particular school, I don't know, but if you get 2 A's and a B at Eton, very, very, very few students get those grades in that school. So considering grades as a signal of talent relative to peers is a much better way of interpreting them compared with just considering them in absolute terms. A-level grades are a construct of talent and hard work. They're a massive construct of social background as well. And then thirdly, and this will sound rather glib, but it's important, we talk a lot to firms about specificity around talent. What do we really value? What really makes a good lawyer, a good barrister? We find in our thousands of hours of interviews with people that many of those things that help people get ahead, on the one hand, have little to do with actual job performance. They might be classified as things like networks, confidence, gravitas. And on the other hand, they're much less available to people who are not from higher socioeconomic backgrounds and from other underrepresented groups. It's about talent and putting the best person in the job. The more specific we can be about what we mean by that, the better. And then penultimately, when we ask people who gets ahead and how in the sector, often, and this is contextual depending on type of firm, etc., work allocation really matters. What gigs do you get put on as a sort of springboard for your career? That is a mechanism for getting ahead or getting ahead more slowly. So more equity around work allocation opportunities is deeply important. And then finally and fifthly, the sort of fundamental question, which I hope we'll explore in the panel, which is what's the sort of task at hand here? Are we helping people try and fit in better into a profession that has been shaped over centuries by affluent white men? Or are we challenging dominant cultures to enable people to thrive equally? I suggest to you it's a bit of both. So, with that context in mind, and I invite you to challenge, question anything I've shared with you so far this afternoon, it's my great pleasure to welcome 4 colleagues onto the panel. Ingrid, I've mentioned, Lady Justice Simler, who's a Court of Appeal judge. I should say your panel here has far too many credentials for me to be exhaustive. I encourage you to read the conference programme for that, and I won't do karaoke with it. But Lady Justice Simler, Court of Appeal judge, but also importantly, chair of the Judges' Council D&I Committee. Tiernan Brady, who's Global Director of Inclusion at Clifford Chance. Natasha Shotunde, who's a barrister, an honorary Doctor of Law at the Garden Court Chambers, and also, really importantly here, co-founder and chair of the Black Barristers Network. and then Michelle O'Hara, who's Managing Director at Thursfields, a full-service company based in the West Midlands. Colleagues, come and join us, and join me in a round of applause for them. I will talk slowly as I walk backwards and get the chair from the stage over here. But Ingrid, while I do this, why don't you kick us off just by reflecting a bit on, introduce, for those who don't know it, the judicial D&I strategy and progress that's been made. I know it was updated quite recently. Yeah. You talk and I'll move some furniture around. Okay. We've been told we've only got 5 minutes. I tried to negotiate a bit longer, but he wouldn't let me. A little bit of scene setting. Nick gave you the statistics for the legal profession, and he said that they were fairly consistent with the judiciary. The legal profession, the judiciary, the JAC now collect diversity data on an annual basis and publish it. We can only publish if there is a 60% declaration rate, and we are struggling, certainly in the judiciary, with other protected characteristics than gender, ethnicity, and professional background. We're hoping to nudge it higher, but the result is that we can't declare our disability statistics. But in terms of gender, as at 1 April 2022, women represented 35% of all court judges and 52% of all tribunal judges. In terms of ethnicity for the same date, 5% of the judiciary are Asian or Asian British in background, 1% Black or Black British, 2% mixed ethnicity, and 1% individuals with a different ethnic background than those. Professional background, non-barristers represented 31% of all court judges and 63% of all tribunal judges. And the majority of judges from a non-barrister background were former solicitors, with only a small number, 6 court judges and 37 tribunal judges, coming from a legal executive or other legal background. So the speed of change is frustratingly slow. I am not proud of those statistics, and I would like to see change move much more quickly. In the judiciary, change is affected by a number of factors, not least the fact that we are a second career dependent on recruitment from the legal professions. Secondly, even though eligibility requirements are quite low in terms of number of years PQE, 5 years and 7 years for the majority of appointments, in fact, people wait on average 18 or 20 years before they apply for judicial appointment. And then finally, turnover rate is very slow. The government has recently increased the mandatory retirement age to 75. So in senior positions particularly, that is another limitation on recruitment. That, of course, all matters. You know it and I know it, but it's worth reflecting on the fact that we're all products of our lived experience and backgrounds. We're not robots. Race, culture, the school we went to, the people we mix with, all play a part in shaping us and bringing our experience of that inevitably as a judge into the courtroom means diversity matters. It informs our decision making. And when a section of society is simply not reflected or not properly reflected in the judiciary, that's a real problem. It's a question of public confidence, it's a question of trust and legitimacy. And of course, at a basic level, it also matters because we want the best judges. And if we're not fishing in the whole of the pool, we're inevitably not getting the best judges. So the Judicial Diversity and Inclusion Strategy, published in November 2020, has an overarching aim to increase the personal and professional diversity of the judiciary at all levels,
not only in terms of recruitment, but then in relation to inclusion, retention and progress, and something that we are much more focused on now than ever before. Two of the core objectives of the strategy are worth emphasising now. One of those is an objective to create an environment in which every single leadership judge across the judiciary has responsibility for achieving these aims, and that's something new. Secondly, supporting and building a more inclusive and respectful culture within the judiciary and the working environment of judges. The other two are supporting and developing the career potential of existing judges and supporting a greater understanding of judicial roles and of in achieving greater diversity in the pool of applicants. We've done a huge amount of work. Nick asked me to update you on things we've achieved. I could talk for hours, but just let me talk very briefly about the fourth objective, the achieving a greater understanding of judicial roles and encouraging greater diversity in the pool of applicants. We have the judicial work shadowing scheme. It operates across the country. It tries very hard to pair people to judges from whom they will learn. I heard that was something that we ought to be doing, and I'm glad we are. We also have a pre-application judicial education programme, which offers a series of online seminars and then some in-person judge-led seminars to create greater confidence and encourage people to apply. Then we have been participating in a targeted outreach scheme with the Judicial Appointments Commission, where we engage with near-miss candidates who've applied for judicial appointment, not got it. They come from less traditional backgrounds, and we work with them to improve their application and to hopefully get through the process next time. We have a huge engagement programme with schools, college and university students. In the last year, 23,000 of them were reached. And the thing I'm most pleased to report in relation to this objective is that we've been working with the organisation Bridging the Bar. I don't know if you're aware of it. It's a wonderful organisation that helps provide work experience, internships, placements for people from minority ethnic backgrounds and less traditional backgrounds. And we are working with them and are offering an internship programme to aspiring barristers belonging to those groups in the High Court and the Court of Appeal, and that will start on the 31st of October. So very pleased about that. Have I run out of time?
Final word.
Well, there's so much I can talk about. I mean, we've got a huge programme in relation to enabling and enhancing the skills of our leadership judges in relation to the culture, because we recognise that some of the things that have been discussed earlier by our colleagues in Solutions are things that the judiciary needs to address too. The culture, is it an inclusive culture? Do solicitors surrounded by barristers feel comfortable when they become judges? Do people from socioeconomically disadvantaged backgrounds feel comfortable in amongst a group of white senior barristers, now judges, who all went to the same public school and go to the opera, and all their children go to public school? It's all of those sorts of issues. So we're doing a lot of work with our leadership judges about how they can be inclusive leaders, how we address the microaggressions that are so much a problem and have such a great impact on many of our colleagues. Should I shut up now?
Let me say thank you very much. Yeah. And Ingrid, I think you've also sort of set the tone for the panel with a sort of focus on action and what's happening, as much as analysing the problem. So thank you very much for that. And Natasha, maybe this is a perfect sort of segue for you to build on some of what you've been hearing so far this afternoon and to reflect on the barrister profession.
Sure, thank you. I heard what the Master of the Role said earlier about not shouting when it comes to trying to convince, persuade, make change in respect of diversity in the profession. I do love to shout, but I won't be shouting today, don't worry. Alongside all the other roles that Nick helpfully mentioned earlier, I'm also sitting on the Bar Council, and I sit on its Equality, Diversity and Social Mobility Committee and the Race Working Group. So I'm very much in the know in respect of the stats, and I'm also very much in the know in respect of what we've done to try and improve things. And I'm going to go through them. I am going to talk a lot about race. That's not to say that there are other protected characteristics that need to be discussed, but it's worth noting that at the bar in particular, and I'm sure in society generally, we've spoken a lot about women, and there has been a lot of advancement when it comes to women. We've generally been talking about that in respect of white women. So I'm going to use this platform to talk about race in particular. And also to note what Nick said about socioeconomic background being one of the biggest factors. It is. But when it comes to race, for example, for black people, I'm very, very confident that we're probably more likely in this society to come from a lower socioeconomic background than everybody else as well, which is why it's important. When it comes to access for the bar, candidates from ethnic minority backgrounds are far less likely to obtain pupillage than candidates from white backgrounds, and that's even when controlling for educational attainment, so university ranking, BPCC grade and degree class. That's stats from the BSB. Thank you, BSB. I'm staring at Mark Neal. In terms of progression, hot off the press, the Bar Council did a study on the government panels for advocates. That's the Attorney General Civil Panel, the CPS Advocates Panel, Treasury Council, and the SFO Council panels. They did it because the government did not. And the Bar Council revealed that the government panels are disproportionately white, shock horror. At junior level, consistently see little or no ethnic diversity. Black barristers are particularly underrepresented, especially black men. Many of the panels have no black barristers. There are only 47 black barristers on panels examined in the report out of 3,082 barristers in total. So that means 1.5% of the panel composition are black. For example, if you look at the Attorney General C panel, there are absolutely 0 black women on that panel, and there's less than 5 black men. I know one. I hope that's not the only one. When it comes to King's Counsel, black and Asian barristers are underrepresented when it comes to taking silk. I think that's not a surprise. Hot off the press, I asked the Bar Council for the stats yesterday. As at the 1st of October 2022, out of 2,019 KCs total, only 8 are black British or black British females. Only 19 are black or black British males. 9 are females from black and other mixed heritage backgrounds, and 22 from black and other mixed heritage. 17 are Asian, and that's from the report, the Bar Council's report that we released last year, and 60 are Asian male. So that just gives you an idea of how terrible the statistics are in respect of us coming in and getting in judicial appointments really quickly. The recommendation rates for the eligible pool of ethnic minority candidates were an estimated 37% lower than white candidates. And in respect of black candidates for the judiciary, they constituted 4% of applications, but only 1% of recommendations, and that's compared to 3% of the eligible pool, with recommendation rates from the eligible pool of black candidates being an estimated 75% lower than white candidates. So everything is disproportionately white. When it comes to earnings, for example, the Bar Council's response to the criminal legal aid review showed that black women earn the least at the criminal bar, that black women who were junior at the same level of experience as white men would usually bill on average £18,700 less than white men. And in terms of the income at the bar report, female barristers from ethnic minority backgrounds are the lowest earning group, with average incomes 41% of those of white male barristers when looking at the profession as a whole. So things are pretty bad. When it comes to black and Asian women at the bar, they're 4 times more likely to experience bullying and harassment than white men. And the Black Barristers Network's report on the experiences of black self-employed barristers showed that the majority of respondents felt that their experience before the bench, that is judges, was negatively affected by their race. They most felt treated inappropriately by opponents due to their race, and most felt that their treatment by court staff was negatively affected by race as well. So things are really terrible. Now I'm going to come on to actions. I'm really sorry, Nick. I did not try to negotiate time. I'm a thief of time. I'm going to talk about 3 actions that have come out from the race working group that I sit on. One being target setting, another one being positive action, and another one being setting out action plans. And I hope that they're going to be helpful for the legal profession as a whole. Target setting. Let's not confuse that with quotas. A lot of people get upset about the idea of quotas. Targets are aspirational goals rather than fixed requirements. Quotas are mandated, i.e. you have to have X number of people from a particular demographic on this. Examples of where target setting can be set. It could be to increase the number of black or Asian pupils, for example, to reduce the number of a particular demographic leaving chambers, so for example women, to increase black or Asian silks, etc., etc. The Bar Council has produced guidance on target setting, which can be downloaded off the internet, and they also are willing to and have given training on target setting to chambers, and I think everybody should consider that. A second one being positive action. Again, I'm going to distinguish that from positive discrimination, which is unlawful. Positive action, there is permitted measures under the Equality Act, which can be done to remedy underrepresentation or disadvantage experienced by members of protected groups within the workplace. And I'm going to focus on the tie-break provision, which some of you may not know about. The tie-break provision is in section 159 of the Equality Act, and it's essentially that if you've got a situation where you've got 2 candidates running for a role who are of equal merit, equal weight, so we've sat there, we've interviewed them, they've both got 22 out of 30, and we're struggling, which one do we pick? One of them has a particular protected characteristic that is disproportionately low in respect of whatever it is that you're recruiting for, or they experience a particular type of disadvantage or hardship. You can then decide, when you're in that tiebreaker situation, who do we pick, to choose that person from that with that protected characteristic. Only when it's in that tiebreaker situation. Definitely do take legal advice on that. But I think that's something that's not used at the bar probably at all, and I think it's something that really should be considered to try and sort out these figures, because at the end of the day, it's not as if you're recruiting those people on the basis of the colour of their skin. They're already good enough for the role. You're looking at them as against somebody else who is equally good enough for the role, and it's at that point that you can make that decision to choose that person to try and increase diversity within the profession. Action plans, there's lots of things. I'm going to cut it and just do a few. These action plans need to be set up by all organisations. The Bar Council has done their own one. They also have a template that chambers can use to set up action plans for different aspects where there are different issues. So, for example, actions could be like reviewing pupillage recruitment panels. Who is on the panel? What training have they had? Have they had more training than just reading the Fair Recruitment Guide, which is the minimum that we have to do at the bar? Reviewing the marking scheme for pupillage applications. Are the weightings unfairly favouring certain demographics? For example, white, middle class men who can afford multiple degrees? Are you putting too much emphasis on masters and PhDs, which are not necessarily necessary to be a barrister? Contextual recruitment has already been mentioned, and a number of chambers already use rare recruitment, which offers that service. Monitoring data on recruitment. Who is getting shortlisted, interviewed, chosen? Is that process being done fairly? Does it have discrimination? Monitoring work allocation. The Bar Council has produced guides on how to do that by race and gender. And I ask the BSB, what are you doing to check that chambers are actually doing that? encouraging ethnic minority members to apply for panels for Casey and the judiciary, making sure that people are clerked fairly and in a way that's sort of pushing them towards that, reviewing complaints procedures to ensure that members can make a complaint, feel confident in making a complaint and know that they're going to be supported, making sure that when it comes to complaints, especially if you're going to go to the regulatory BSB sort of arena, that people understand how complaints work, the different stages. We did a fantastic, this is the Black Barristers Network, did a fantastic webinar with the BSB, with COIC and others, basically going through complaints and complaints procedures, which is on YouTube if you want to watch it. Training, the Bar Council has developed race awareness training, which discusses race in particular, and they have trainers that can deliver that training so that we can hopefully change the culture. I don't like using the word culture when it comes to racial discrimination, but I think it's something that's really important. And finally, what can the regulator do? We need teeth. The Bar Council has produced a lot of guidance and support for chambers, but chambers is a collection of barristers with individual practices that they have to do that, quite frankly, often either don't have the time or don't really care enough to actually implement these policies, to sit down and actually do the action plan. So what we need is not just the carrot, we need the stick, and we're begging for the stick. I want you to ask chambers, what is your action plan? Show it to me. How have you set targets? If so, have you met them? If not, why haven't you met them? Those are the sorts of things that we want the regulator to do to make sure that things change. And the government, because I heard that there were representatives from the government here, they might have left, please look at your panels. Please look at the composition of your panels. Please do the analysis to work out why they're so white and make a change. I hope the Master of the Rolls doesn't think I was just shouting there, if he's still here. And also putting pressure on appointments commissions, judicial and KC ones to basically sort themselves out, because these statistics are ridiculous and they really need to change.
Natasha, thank you. What a tour de force. There's lots I'd like to explore and unpick there, but I will make sure we give time to other members of the panel as well. But I heard loud and clear there, regulators, we want the stick. That will be the quote, doubtless, from the panel. Michelle, over to you. We've talked about the bar, the judiciary. Most of my exposition looked at data of large city law firms, but of course the majority of the practicing population in law does not reside in those populations. The majority are in regional law firms. Give us your perspective on this and some practical actions in your firm where resources might be more limited for this type of work, but perhaps you have more dexterity and room for innovation.
Yeah, sure. So thank you, firstly, for the opportunity. Give you some context. Thursfields is a West Midlands-based law firm. We're a traditional law firm, even though we're a limited company. We have about 150 colleagues, and we're spread across 5 offices. The SRA regulates about 9,700 firms. So let's cut the top 20 out, who probably have an income of more than 12 million a year. And the remaining 9,500, that's critical mass. That's the SME space. And really today, we just want to talk about the practical and the actionable things that a firm like ours in that SME space has been able to achieve. We are really keen to collaborate with other law firms, and very grateful for the support that we've had from other organisations. When we've knocked on the door, they've welcomed us in. So there's a real strong need for greater collaboration, I think. You're right, we don't have big budgets, we don't have big HR teams, but I would say you don't need either of those to make a difference. You need intention, you need creativity, and you need some passion. And so let me tell you a little bit about our journey. I'm watching the clock as well, don't worry. So we thought, let's do some ED&I training. So we paid a trainer, a good trainer, to come in. We persuaded all our partners to attend. There was pizza, there was conversation. We were quite excited. And then what happened? Nothing. So back to the drawing board. And we thought this time we're going to go top down and we're going to go bottom up. top down means that for our 4 annual goals as a business, we made one of those to develop our inclusive culture. Lawyers, and I say this as one, we do love a goal. We love something to strive towards. So we made it part of our line of sight for our business. Bottom up, that meant all the little things that we were going to do. And at this point, I would really like to give credit to my HR director, Jade Linton, who's in the audience as well. She is my partner in crime in this work. And I think it's really important to have that support and to have someone with whom you can persevere, because it does take some perseverance, I think, to develop culture change. And this is a journey. So we started with pay. Sorry if that is a dirty word, but it's very difficult to create a sense of belonging in an organisation when you may have 2 colleagues who are paid differently simply by reference to their gender or their ethnicity. It really doesn't make any sense. So we looked at how we could create pay parity, and we recognised there's some anomalies in our payroll, and we tasked ourselves for 3 years. Every year, in addition to our pay review, we would also have a levelling up conversation. We would challenge ourselves to say, why is that colleague paid that much and this colleague paid that much? And simply the practice of questioning that made us every year create some levelling up exercises with people's pay. The next thing we did is stop paying people according to their salary in their previous job role. So candidates come from a wide variety of backgrounds. And I guess the temptation for businesses is to look at what somebody's paid and then think, okay, we'd like them in our organisation and we'll add a couple of grand. But actually, all that does is create pay anomalies in 12 months' time for your business. So we decided to stop that practice. And actually, we decided, first of all, what's the range that we want to offer for this job role? And then let's find the candidate. And they deserve that wage for that job. And the third thing we did is to become a Living Wage Foundation employer. If you're not a Living Wage Foundation employer in the room, I urge you, go look it up. It's a really easy organisation to work with. And it commits to provide a living wage, which is higher than the national minimum wage, to colleagues. Now, we're not required, because of our size, to undertake gender pay reporting. But when we ran the numbers, we have no gender pay gap. We are a full-service law firm. Thank you. We're a full-service law firm, and if you may be sat in the audience thinking, well, it's maybe different, Michelle, for your business. We're larger than you, we're smaller than you, you've got a female leader. All of those things may be true, and you can still do something about pay. And for us, we're now working with our HR team to check whether we have any anomalies in our ethnicity pay and getting that data together so that we can be sure that we're addressing this consistently. We're also a profitable business, so if you're sat there thinking, we can't afford to do this as a business, I would challenge you to say, can you afford not to do it? If you want an inclusive workforce, if you want to capture talent, then it definitely merits thought. So secondly, and I'm going to speed up, sorry, diverse talent. So we spotted that Aston University was running a programme with a large Birmingham law firm, and we thought, that looks great, let's see if we can have a bit of that action. So we knock on the door. Aston were brilliant. They worked with us. They enabled us to run a widening participation scholarship scheme aimed at Black, Asian and minoritised ethnic students. Those students, we offer work experience to them in their second year at university. We also then offer them paid employment during the summer. They have the opportunity for mentorship. They have a guarantee of a training contract interview. And when it comes to several comments made today about getting work experience on your CV, it's a great opportunity and has been really beneficial for our business. Thirdly, reverse mentoring. So not going to say we know an awful lot about about probably the research that's gone into reverse mentoring, but we thought we'd just jump in. So we watched some YouTube. We spoke to a couple of people who work in the public sector or larger organisations who know a bit about this stuff. And then we invited our trainees to see if they would be a mentor to me as managing director. And very luckily, one of our black trainees said yes, they would be up for the challenge. And it was as simple as committing to go for a walk together every 6 to 8 weeks. And we had some boundaries around this. My job was to listen. Stepping out of the role of leader and into mentee was really quite important. My learning in this process was my responsibility and not their burden. And listening, actually, for a lot of leaders, it's good to shut up. Sometimes it's good to shut up and listen. It was such a beneficial experience. I think I can probably say from both our perspectives. So I'd really encourage any leaders just to have the confidence to put yourselves forward and say, is there anyone junior in my organisation who is willing to share their experience of what it's like to be in my organisation and share their lived experience, which may be very different to my own? How long have I got?
Final word.
Final word, okay. Couple more things. Conversation is really important at Thursfields. Being comfortable with uncomfortable conversation. We've done an initiative around that and it was really awkward, but really successful. And I guess the final thing I'd want to say is that leadership is really a privilege. So if you have a position of power or privilege, then why would you not want to use it to influence and make a difference in this space? Thank you.
Michelle, brilliant, thank you. And I really get a sense from what you've shared of there being no silver bullet here. It's about punctuating working life with being comfortable with uncomfortable conversations, inviting feedback from colleagues. Those things feel to me to make the biggest difference to creating inclusive environments. They're not initiatives, they're just the way we do work together. Let me turn finally to Tiernan. Tiernan, one of the sort of highlights in our research is the way in which the behaviour and expectations of clients affects inclusive environments. Can you reflect a bit on that aspect to this? And then maybe secondly, and probably separately, drawing a bit on your personal experience around campaigning as well, how that can have an effect here. Two simple topics for you.
Two small topics, which we will do in this little clock here. I think there's two angles to the client piece first. It's a really interesting angle because first of all, it's a client need and it's also client demand. And they're two very different things. So our clients increasingly are telling us we must get better and they are demanding more and more data and they are demanding more and more performance, and that's all healthy pressure as long as that's based on respect and collaboration. Sometimes it is and sometimes it isn't, and sometimes it's performative. When I was a teenager, I had a T-shirt, which, does anyone remember Garfield the cat? And it was Garfield beside this gigantic dog. And it said, the easiest way to look thin is to stand beside someone fatter than you. And the way they do this with targets sometimes is to say, here, you need to get better. Thanks very much. And you become, as the law firm, their demonstration of their values. That they are announcing to you, you must improve. Now, I'm not saying that's unhealthy. I think it actually is healthy because it creates it. But as long as it's happening on the other side of the door too. And so there's two types of relationship on that one. It can be collaborative, and those relationships with clients are magical because they start to bring in reverse mentoring that you can do between firms. They start to connect role models and sponsoring and coaching and mentoring. And when it's based on that equal respect, the sky's the limit on how much change you can drive with a healthy relationship and a client. And then some of us just more solely stick without any sense of that partnership model. It does drive change because it creates focus. There's no doubt about that. But in the long term, I'm not convinced it's the healthiest approach. I think the other bit about inclusion, which is the client need piece, which is only going to, I think, explode, which is, you know, to say, when things become important in society, the first thing we do is regulate them and write laws about them. And inclusion is becoming important in society, thankfully, so we're writing regulations and laws about them. And it turns out, at some point, law firms are going to be one of the first calls by our clients when they have an inclusion question or inclusion need. So whether we're talking about data, and again, for organizations only operating in one country, it's already complicated enough. For organizations operating in 2 or 10, what am I allowed to ask someone? Where do I hold that data? I mean, is it illegal to ask people, as it is in, for example, in most of continental Europe, to ask anything apart from gender? And most firms don't know that at all. So there's a huge legal privacy and data need. There's an increasing risk and compliance need. There's a massive employment area need, regulatory change. You know, you can see the EU Commission now talking about bringing out the European Women on Boards Directive, which is going to insist on minimum percentages on boards. What does that mean for your clients? So our clients, when they think of inclusion, are going to think more and more about, I need to phone my lawyer. And I think that's a great thing, but it means as law firms and as lawyers and as people who are practitioners of the law, it's something we need to get good at, because it's something our clients are going to need. And funnily enough, as we get good at it, we'll get good at it. Because once you can learn more and more about what this looks like, that of course has a great knock-on effect positively on your culture. So that's the client piece. That condensed as much as an Irish person can condense anything, I suppose. I think this totally thriving on them, living off them. I think the other bit is the campaign piece, and I think maybe I was thinking about all the initiatives and the change the rules and change the culture examples that are here as well. What might be useful? Because I came to the firm from campaigning, having run the marriage campaign, the referendum in Australia. On the yes side, I should say. I'd been a remarkably unusual hire as the director of conclusion if I campaigned on the no side. So just clarity. And before that, since I obviously don't sound very Australian, I was the political director of the Irish referendum. And funny, when I came to Clifford Chance, that's the reason we came. First of all, one, I really didn't have any desire to work in business. But law and inclusion aren't distant cousins. They're intertwined. They're built on the same principles. So this is, being good at inclusion should never be something that a law firm does as well as being a law firm. It's not like Airbus where you make planes and I have an inclusion program. This is something where the foundational values are just a different set of language for the same foundational values, I would argue. So when we came to the firm, we talked about what does that look like in a law firm? What does that mean for people who want to be campaigners? Because to us, to me, it always was a campaign. It's a social change campaign. You're building your culture. And that's a social change campaign, which means now you have to think about what does successful campaigning look like. And there's 2, maybe 3 very quick points that I thought might be useful, hopefully, from the previous campaigns that we've applied at Clifford Chance, but that might be useful for anybody anywhere. The first was we realized people were terrified to talk to us about inclusion at all because they were terrified to get it wrong. As we were heading towards the marriage vote in Ireland, we realized this wasn't just a problem between strangers. People didn't want to talk to their Auntie Mary about, well, I want to tell Auntie Mary what it's like to be a lesbian, but I don't know I don't know how to ask that question. I don't want to get the terminology wrong. I don't want to be disrespectful. Therefore, I don't speak at all, and there's no change happens because we couldn't create the space for conversation. And at the same time as we were trying to work that out in the campaign world, and even more so, I would argue, in workplaces and law firms, the world outside is doing the opposite. It's shrinking the space where conversation can happen. We turn on our social media, and it's easy to blame social media. We can turn on national media too. National media has just become a bigger version of social media. The loudest voice will get on the panel. Question time should have a fight for it to be entertaining because it's competing with, I'm a celebrity, get me out of here. And that's what our producers and our directors think. So the spaces where understanding happens is shrinking all the time. So as workplaces, we have to do the opposite. We have to build that campaign space out. We have to allow people to see, you don't have to be an expert to be an advocate. Because if people feel to join the inclusion journey in your firm, they have to already be perfect, nobody can start. And since there's no such thing as perfection, and since we are all imperfect, nobody will ever be able to start, and no one, even if they could scrape into the race, could ever finish. So we have to build a space that allows the joy of error rather than the terror of error. Because that fear stops the conversation, it stops reverse mentoring, it stops that wonderful space where people realize, oh, okay, I can see an awful lot more now, I've learned an awful lot more. And the final piece that ties connectly into that is because it's not enough for us to believe in inclusion in our heads. Our firms are filled with people, I would like to think, who have great values and believe in inclusion, but a value you keep in your head is a secret. A great campaign has to pull it out. Your workplace has to pull it out. And we have brilliant people who are sitting there thinking that the simple act of passive non-discrimination is in some way creating inclusion. I'm a great person. I'm sitting there, I'm doing nothing wrong. My team must automatically know that about me. And you're going, why? Why would your team think or presume that you're this brilliant ambassador for inclusion when it's in your head and you've never let them see it in the way you behave, in the way you work on your team, in the way you talk to others, in the people you select for your work? And getting people to realize, I think, that piece, A, you don't have to be an expert to be an advocate. B, people come to work from the real world. And the real world has taught them it's not always fair. And you don't always have to be treated badly every day. You only have to be bullied once or twice. You only have to have had a homophobic or racist or sexist comment. And you're aware it can happen. So people come to work on our teams knowing that that's the world. So each one of us has to think about, how have I actively allowed that person to realize that that's not me and that that won't be this place. So a value you keep in your head is a secret, and don't wait to be an expert. That's it.
Great, thank you. Fantastic. 4 different complementary perspectives, all approaching this topic from different angles. Colleagues, we've got just a few minutes for questions, including any that might have appeared online, and making sure we're including people who are joining us virtually as well. Colleagues on the floor, any questions, challenges that you'd like to pose just before we finish up? There's a hand at the back of the room. And on the left here. Well, let's just take all 3 of these questions at once and we'll endeavour to answer them in the best way.
Hi, Shanette Thompson from Kingsley Napley. Firstly, to answer your rhetorical question, no, there shouldn't be a business case for diversity. We don't have to make a business case to hire a white man, so why should we make a business case to recruit anybody else? Also, I wanted to say thank you for the research done by the Bridge Group, because I'm the firm's training principal, so I read it quite cleanly about SQE and diversity. So I just encourage you to do more of that work and give the profession all the data it needs.
Thank you. Really helpful points, and I will embrace the compliment as well. It's the question we get asked the most, particularly by senior people in law firms. Can you show me the business case for diversifying our board? And you'll be reassured to know my response often is, show me the business case for having 90% white men on your board. Why have the counter-argument? Here, there are some other hands, please. Let's take as many comments as we can.
Shall I start or not? No. Do you want me to start?
Yes, please.
Okay,
Yeah, sorry.
I'll try and be quick.
There's a sort of dislocated voice coming through the speakers.
Okay, dislocated voice. One quick comment and 2 questions.
Thank you.
The comment is about the, I think Natasha called it the tie-break provision, and I think in judicial appointments it's called the equal merit provision. I would encourage all barristers' chambers to use this as much as they can, but just a warning, I suppose, don't expect it to be a quick answer. I do think in judicial appointments, it's not going to make very much difference in about 100 years because of the tiny number of appointments that actually get made on the equal merit provision. It's so small. It needs to be broadened into a roughly equal merit provision, but that's for another day. My 2 questions, and it's largely for Lady Simler. The first one on this outreach to the nearly misses. I think that sounds as if it could make a difference. Do we have any statistics yet on how much impact it's making? Second question is, I suppose the one that's worrying me most is that we know on gender this sector has made some quite good advances in the last 20 years. Not still much work to be done, but a lot of good things happening already. On race, it's not so good. We know that things are pretty poor, and again, Natasha gave us some pretty horrible statistics on that. But on disability, we don't even know how bad we are. And that's even, that's terrible, especially in the judicial field. So what's the single thing that we need to do to make a big difference on the disability agenda? Because I do think that's one that's been ignored for far too long.
Thank you very much. Let's take two more comments, and then we'll address some questions in a second. So I'll hold on to those questions. I've noted them here.
Hi, thank you.
Thank you.
A couple of observations, really, rather than comments. Really like the action focus of the panel's contributions a moment ago. My name's Jonathan Bourne. I run an apprenticeship training provider called AMR Training. We specialise in legal apprenticeships, an area I've been involved in now for probably 12 or so years. A couple of other actions for you. One, to congratulate Clifford, Norton, Rose Fulbright, about 17 other firms who yesterday announced something called the Apprenticeship Pledge, which is all about treating academic and vocational pathways, particularly apprenticeship pathways, equally. So take a look at that and get involved. And Michelle and Thursfields are also closely involved in apprenticeships. The second action is that not many people know that there's a government consultation running at the moment. It runs until the 18th of November, looking at how apprenticeship pathways into the law can be improved so they are more inclusive and better in terms of social diversity. They're not as good as they could be at the moment, and I say that as an apprenticeship provider. It ends on 18th of November. We've not got long. Conservatively, there's probably £100 million worth of government money that's going to go into this over the next 10 years. So if we can get it right, it will make a big, big difference. So have a look on our website at amrtraining.com or go on the IFATE website and do have a look at that consultation and get involved, won't you? At the moment, there's just a very small number of firms who I think are even aware that that's going on.
Jonathan, thank you. Well noted and important points about apprenticeships. Let's have one final comment. Thank you.
Jane Burton, I'm chair of the Lawyers with Disabilities Division of the Law Society. We've been going for over 30 years. I wanted to draw people's attention actually to a piece of research that was done by Cardiff University Business School called Legally Disabled, and I urge all of you to read it because it's a very collaborative piece of work. It's done in co-production with Lawyers with Disabilities and with barristers as well. It is online. There's an executive summary. There are a lot of recommendations within it. We ran a group of roundtables around the country online at the start of the pandemic, and we found it was fear. People didn't know what to do. So we have published an easy wins document for law firms, one for large, one for small and medium law firms, and also a reasonable adjustment guidance with lots of links and case studies. So I just urge you all, if you're worried, you need to do something about disability because it's dreadful out there for people in my division, and I just want to get over this wonderful piece of work and the pieces of work we've done to follow up with that. So thank you.
Great, thank you, Jane. So for colleagues who might have missed that, Legally Disabled is the name of the report. And it links to the question. We'll have Ingrid maybe give the final word here. The question about the near misses scheme, and then maybe any reflections on disability, and then we'll wrap up. Thank you.
So in terms of the targeted outreach scheme, I think from memory, and I didn't look at it before I came, I should have, we have been working with, mentoring, encouraging, enabling about 60 candidates over the last 2 years. The scheme's been running for 2 years. We haven't yet had a competition in which one of those candidates has applied and the competition has come to an end and we've got a result. So I can't give you statistics. What I can tell you is that the individuals who are going through the process, who've applied before and not been successful, and the judge I can't remember what we call them, judge mentors or judge teach, whatever they are, both speak really positively about the scheme, and I am really optimistic. I agree with you. I think it does have the potential to achieve some real change. So, sorry. On disability, the declaration rates aren't sufficient to get the statistics, but that hasn't stopped us from working on disability issues. So we haven't said, oh, we haven't got the data. We know there are disabled people within the judiciary who come into our courts with disabilities and who need access and reasonable adjustments. We have a very good judicial workplace adjustment programme. We have enhanced that programme in order to ensure that it has tight timescales that are adhered to by Her Majesty's Courts and Tribunal Service in providing judges with the adjustments they need. I know that there are issues around buildings. We've got an establishment across the country that hasn't had the money put into it to ensure that the lifts work or the facilities are available as a building, and that's something that, you know, there's nothing the judiciary can do. It's a matter for government, it's a matter for MOJ, it's a matter for HMCTS. But we are doing what we can. We've got a project looking at the moment in the RCJ at accessibility issues. And we're going to learn lessons from the RCJ, the Royal Courts of Justice, and then roll those out, I hope, to the courts all around the country. So we're not being held back by the lack of data in doing something. We are doing something, but we don't have the data, and I think that's because people are afraid to say, I've got a disability in many cases. But
Ingrid,
I
thank you. I think I'm getting the red card from the back,
Sorry.
so we must wrap up in the kindest way, of course. we must wrap up. Colleagues, thank you for the opportunity to spend some time on this topic, for engaging with it, and for the thoughtful and helpful comments from the audience as well. Join me in just thanking our panel, Michelle, Natasha, Ingrid and Tiernan.